This video provides general information only and is not intended to be legal advice. If you require legal advice, please speak to a lawyer. This video is for parties involved in a minor case consumer trader claim at the Magistrates Court of Western Australia after receiving a listing conference notice. If your claim relates to a different type of matter, this video may not be relevant to your situation. I'm going to guide you through the process of what to expect and give you general tips on how to conduct yourself when at the court. This is an example of a listing conference notice. On the listing conference notice, you'll find the day, time, and location of where you need to go. You must attend a listing conference in person. Minor case consumer trader claims are generally conducted in private and with little formality. However, it can still be stressful to be in a courtroom. You may wish to bring a support person, such as a relative or friend. If you need an interpreter or other assistance to attend court, such as audio visual aids or a guide dog, you must contact the registry office as early as possible. You can do this using the contact details at the top of the listing conference notice. On the day of your listing conference, make sure that you arrive early and are dressed in neat, smart clothing. If you are late or do not attend, the magistrate can make orders in your absence, including ordering judgment against you without a trial. It is difficult to estimate how long your hearing will take, so it is best to avoid making any other commitments on the day of your listing conference. Some of the things you might want to bring with you are documents that are relevant to your matter. Have these in an organised format so that you can get to them easily. A list of the witnesses you will be calling to give evidence at the trial. When you arrive at the court, be prepared to go through airport-style security, so don't bring any sharp objects with you. You may need to remove your shoes, keys, belt, and electronic equipment, including your mobile phone. Do not smoke, eat, or chew gum in the court building. Taking photographs or video recordings is also not allowed. Each registry office has a notice board which lists the location of each hearing. Check the board in case your hearing room details have changed. When you arrive at the courtroom, the door may be locked. Let a court officer know your name and your case number. Then take a seat outside the courtroom. Your matter may not start exactly at the scheduled time, so please be patient and do not leave the area. The court officer will call you into the courtroom when the magistrate is ready to hear your matter.
Nadine Jones, Fenton Smith.
Make sure that your mobile phone is turned off before you enter the courtroom. Also, remove any hats and sunglasses. When you enter the courtroom, it is proper etiquette to show respect to the authority of the court. You do this by bowing your head to the coat of arms behind the court bench. It symbolises the administration of justice. If you are the claimant or the party making the claim, take a seat on the right when facing the magistrate. If you are the defendant or the party defending the claim, sit on the left when facing the magistrate. The magistrate is a judicial officer who administers the law and conducts a court. The magistrate sits behind the court bench. If you have brought a support person, they should take a seat in the public gallery. When you are in a courtroom, address the magistrate as Your Honour or Magistrate.
Nadine Jones for the claimant.
Yes, Magistrate.
And for the defendant, Fenton Smith.
Yes, Your Honour.
Thank you, Mr. Smith. You may be seated.
Refer to the other party politely and do not interrupt them. Each of you will have an opportunity to speak. Stand up when speaking, sit when you have finished speaking, or when the magistrate tells you to.
Thank you, Mr. Smith. The purpose of a listing conference is to list the case for trial. It is not to decide the matter, but to set a trial date. Part of this involves finding out whether all parties have their documents ready, working out how many witnesses you each intend to call, and working out how long a trial might take. With a minor case consumer trader claim, you may not have had the chance to discuss with each other whether you can settle the dispute without going to trial. If I think that you might be able to do this, I will send you to a pretrial conference before a registrar. This is a mediation process to give you an opportunity to discuss your dispute and to either try to resolve the matter or to try to narrow the issues in dispute that do go to trial.
There are many good reasons to try and resolve your dispute at the pretrial conference. For example, after a trial, the court can only make specific orders, such as the payment of a sum of money or the replacement or refund of goods. At a pretrial conference, the parties may agree to other things, such as making an apology or refraining from posting negative comments on social media. Preparing for court is a time-consuming and costly process. This involves time away from your family, running your business, or working while you prepare for the court, attend court, and file court documents. It is also important to know that agreeing to settle your dispute does not mean that you have lost. It can be another way to achieve the outcome you are seeking.
Thank you for attending today's listing conference. I have read the documents that you have filed. Now that I've also heard from each of you, I am of the opinion that it would be beneficial to send you to a pretrial conference. I encourage you to approach the pretrial conference with an open mind and to make a genuine attempt to settle your dispute, or if you can't do that, to at least try and reduce the number of issues between you. Please go outside and a registrar will collect you. The matter is adjourned.
When the registrar is ready, they will collect you and take you to a pretrial conference room. The registrar will be seated at one end of the table. The role of the registrar is to try to help the parties reach a settlement that is acceptable to everyone. The registrar cannot give legal advice.
The purpose of a pretrial conference is to explore whether you can reach an agreement to settle your dispute. What you say in this pretrial conference is confidential. All of our discussions are without prejudice. That means that anything you say cannot be used by the other side against you if the matter does proceed to a trial. So I encourage you to speak freely to one another without being concerned that your statements will later be used against you. Remember, the reason we are here is to make a genuine attempt to settle. So I encourage you to have an open mind when we have these discussions.
When considering whether to settle, it may be helpful to ask yourself, what is your starting position? Whether you are willing to move from your starting position, and what do you really want? For example, if you actually want an apology, remember that the magistrate cannot make this order, even if you succeed at trial. If the parties cannot reach a settlement, the registrar will list the case for trial. You will be notified of the date, time, and place of the trial in writing by post. We are not covering preparing for trial or the trial process in this video. If you reach an agreement, either at the pretrial conference or at any other time, you should record the agreement in writing, signed by all parties. The registrar can assist with this. The agreement becomes a judgment of the court and can be enforced if a party does not comply with it. We hope you found this video useful. If you require legal advice or assistance, you can contact the Law Society of Western Australia. If you're feeling anxious or depressed and need support, please contact Beyond Blue or Lifeline. Thank you for watching this video, and we wish you all the best with your matter.